Sorry to have kept you waiting. Yes.
Not at all, my lord. My lord, my lady, may it please you, I appear on behalf of the second appellant, a person whom we refer to as the husband, together with Mr. Ben Boucher-Giles behind me. My lay client is immediately behind my junior counsel. The wife, who is referred to as Miss de la Sala, slightly confusingly as the intervener was Mrs. de la Sala, was always referred to during the proceedings without any disrespect as the wife, is represented by my learned friends Mr. Justin Warshaw, KC, and Mr. Edward Cumming, KC, and they in turn lead Mr. Joshua Viney. The wife, or Mr. de la Sala, sitting in the front row. The intervener, which is Mrs. de la Sala, is at the very back of the court, together with her son Edward. She is instructing Mr. Dackershagen, who is on my immediate right, Dackershagen KC, and he leads Mr. Andrew Gurr.
Thank you.
My lords, there are, of course, two appeals for the Court of Appeal in this matter. I'm dealing with the one...
Sorry, we switched them round at the last moment, but thank you for accommodating that.
Not at all, my lord. Thank you. I'm... excuse me. In respect of the financial remedy appeal, the point is a fairly short one, which is to do with the question of materiality. And what I was proposing to do was say a few words generally in opening about what the Deputy High Court Judge was concerned with was essentially an evaluative exercise rather than a discretionary one. He had to decide that it would have made a material difference, that non-disclosure. I made some comments about what that non-disclosure is, and then I'm going to come on to 4 points as to why we say it could not have been material on an evaluative basis. Those 4 points deal with, first of all, the wife's own state of knowledge at the time of the entering into of the order. Second, in respect of the question of whether or not, had it been known that there was a gift in prospect, of course, gift had not been made, there was simply the husband being told that he might be made a gift in due course, that would not have affected the wife's needs case. Third, it would not have affected a sharing case. And then fourth, a comment as to the wife's own knowledge and attitude, and whether or not this would have made any difference. And that's made in the context of her pursuit in New South Wales of a claim, which she has since amended, but still pursues with considerable vigour, that she is entitled, as of right, to a sum of at least £62 million there. And that's all born of what she says is a knowledge that this money that went to the husband should have been returned to him in any event. And indeed, one of the remedies that she seeks, both in her original statement of claim and in the 3 subsequent iterations, is that that money should be returned to the trust, or it should be paid to her in any event. So those are the 4 points. And in dealing with that, what I proposed to do was, first of all, briefly set out a law which I appreciate is already very well known to this court, but doesn't lose too much, I hope, by way of repetition. Then come on to the background circumstances which informed Deputy District Judge Smith's orders, and then the order of Deputy High Court Judge Hess, and then a development of the 4 points, and then 1 or 2 points in reply to some of the things that said in my known friends' notes. In terms of the law itself, it's almost trying to repeat it, so well known to the profession, but I will repeat it. There is, of course, the famous description of Lord Brandon of Oakbrook in the case of Jenkins and Livesey, which in my Lord's bundles is authorities page 56. This was, of course, a case of a non-disclosure by a wife of an intention to remarry, something which would have, had it been disclosed, fatally undermined any maintenance claim that she might have had. And it's the paragraph which is quoted by Deputy High Court Judge Hess, which there's no dispute as to its currency even in today, despite this being now a decision of some antiquity. And Lord Brandon says that letter G, on authorities page 56, his famous emphatic word of warning. So having said that non-disclosure does potentially open up the opportunity for setting aside an order, he then deals with materiality here. I would end with an emphatic word of warning. It is not every failure of frank and full disclosure which would justify a court in setting aside an order of the kind concerned in this appeal. On the contrary, it will only be in cases when the absence of full and frank disclosure has led to the court making, either in contested proceedings or by consent, an order which is, and then this is where we placed particular emphasis, was on the adverb substantially, an order which is substantially different from the order which it would have made if such disclosure had taken place, that a case for setting aside can possibly be made good. He then goes on to say, and we say this is just by way of example, and is simply colouring the earlier rather than confining it. Parties who apply to set aside orders on the ground of failure to disclose some relatively minor matter or matters, the disclosure of which would not have made any substantial difference to the order which a court would have made or approved, are likely to find their applications being summarily dismissed with costs against them.
Well, that's just the other side of the same coin, isn't it?
It is, and so the question has to be one of, my lady, emphatically one of, would there have been a substantial difference? And that's what the court had to deal with. That is sort of
Substantial as opposed to trivial or minor.
yes, indeed. So if there was, and this is where then the questions of how the judge might have exercised his discretion differently, or matters of those kind, come into play. Because if it turns out that the wife had in mind that there was going to be this fortune in prospect, which we will say she did, and that ought to have been the finding, then it really does become a question of simply one of timing. If it could have been the case that the money was paid, say, 2 years later, and there was no basis for a remedy, then why would there be a particular remedy if the money was paid earlier on the particular facts of the case? And that required the judge, we say, to conduct an analysis as if he had been at the time of the hearing. And that substantial approach receives support at page 41 from two of the other of their lordships, where, first of all, Lord Hailsham, at page 41, letter B, again brings emphasis to this, and again in the context of what has happened subsequently. One of the reasons that it was said that the husband did not disclose the offer of a gift was because he wished to avoid exactly this, the enormous expense that has followed. And Lord Hailsham says at letter B, I'd also wish to underscore the warning with which my noble and learned friend is concluding his speech. Consent orders which effectively break between former spouses are when there has been full relevant disclosure, much to be encouraged, and properly negotiated greatly reduce the pain and trauma of divorce. They are therefore not likely to be overthrown.
He's making a point there that's repeated by Lord Brandon about the context. Full relevant disclosure.
Yes.
And Lord Brandon at page 48 comments that unless the court has been given correct, complete and up-to-date information, it cannot lawfully or properly exercise its discretion.
Yes.
And that is where the obligation to give full, or why the obligation to give full and frank disclosure of all material facts arises. So that's the context in which this issue is addressed.
Yes.
That there is a weighty, you might say, obligation on both parties or all parties involved in financial remedy proceedings to give full and frank disclosure.
Well, we agree with that, my lord. The question then comes about as to if that disclosure doesn't happen, and I was also going to repeat, although it simply
But sorry, I was going slightly out of course. You took us to what? You were going to take us to
Well,
what one
I
of the
was
other?
dealing with the sport. There was Lord Helsham and Lord Scarman then, in similar terms, says slightly further down the page, again, affirming the importance of these consent orders and the clean break. At letter D, says, before leaving the case, I wish to express my firm support for the emphatic word of warning with which my noble and learned friend concludes his speech. The principle of the clean break as formulated in Minton, and at page 608 by Self, retains its place of importance in the law. The justice of the clean break depends upon the full and frank disclosure of all material matters by the parties. But orders, whether made by consent or in proceedings which are contested, are not to be set aside on the ground of non-disclosure if the disclosure would not have made any substantial difference to the order which the court would have made. That jurisprudence is then developed by cases such as Charland, which say that the burden is firmly on the husband to show that there would not have been a substantial difference. And what we say is, in this case, he did advance such a case, and it was on those 4 particular bases. And when Deputy High Court Judge came to deal with them, he didn't investigate that as the second part of what was in effect a 2-part test, or he didn't investigate it sufficiently. The first part about non-disclosure, he's made his findings about that. Those are not the subject of an appeal. The materiality, though, he deals with, and I can skip straight to there. It's at page
Are you taking us to Charland or not?
I am going to get to Charland. In Charland, and my learned friends, I apologise for Charland coming in later. It's at the very end of the bundle, and it should now be on pages 1409. Where?
Don't worry, we had 2 copies of Go Hill, and what?
Yes.
Yes.
I can only apologise
Don't
for
worry
that
at all.
having happened. I can only assume that someone thought Go Hill number 2 was a secondary case. But at 1409 of...
Could you give me, because I've got an unpaginated copy of it, could you give me the internal page numbers, please?
Certainly.
Or paragraph numbers of Charland?
Yes, indeed. So, my lord, if we could turn to page 880 in the appeal cases report. This is, of course, Charland and Charland reported in the UKSC, page 60, in the year 2015. And at page 880, which is in the authorities bundle, for those who are following it in the authorities bundle, page 1409, there was a review by Baroness Hale there of what had happened in the Court of Appeal, Lord
Yes.
Justice Briggs. Just to set the scene, this was a case where after a draft order had been settled and approved by the judge, but before the order was sealed, the wife had discovered that, contrary to what the husband had said in his evidence at the hearing, he'd had discussions with investment bankers as part of active preparations for initial public offering of a company, and that the husband's shareholding was therefore likely to be valued at a sum far in excess of that which the court had relied on. And we said this is a fairly clear case of materiality, because even if the IPO didn't go ahead, the fact that this was in prospect would, of course, affect the valuation. And at paragraph 15, Baroness Hale deals with Lord Justice Briggs's dissenting judgment in the Court of Appeal below, in which she says, in a vigorous dissenting judgment, Lord Justice Briggs explained that the husband's fraud was material to the agreement and the consent order for 2 reasons. First, it undermined the basis on which his shareholding had been valued, and therefore the ability of the wife to address the proportionality of agreeing a discount below her claimed 50% against receipt of larger share of the other family assets. Secondly, it created a false basis for the wife to assume that delayed realisation of the husband's shareholding might justify a tapered reduction in her share of the proceeds. And that's taken from paragraph 30. She goes on to hold that once the judge had decided the husband's fraud had undermined the parties' agreement and the consent order, that should have been the end of the matter. And then there's a discussion about fraud unravels all. We say this is a paradigm case, Charland is a paradigm case of where the court finds the non-disclosure and then relates it very clearly back to the materiality. That's not this case. There was nothing in this case that would have altered the decision before Deputy District Judge Smith. The wife knew about the enormous fortune. She knew it was going to be distributed to the next generation. She had an expectation that her husband had displaced her in that distribution. She knew all that. Second, she also took that into account before Deputy District Judge Smith. There's some movement in the percentages, but one of the figures is she gets 81% of the assets. Deputy District Judge Smith was troubled about that. I'm going to return to that. And it was explained in part on the basis that the husband was going to get more by way of money from her family. In any event, in the case of Charlotte, the Baroness Hale then goes on to deal with the rationale of the dissenting judgment of Lord Justice Briggs, to say that once the judge had decided that the husband's fraud had undermined the parties' agreement and the consent of that should amend the matter, and there were three interrelated reasons for this. First, the general principle that fraud unravels all is no less applicable to court orders than to contracts. Second, Lord Brandon's obiter dictum in Livesey had been misinterpreted. He was drawing a distinction between triviality and materiality as at the date of the order, not at some later date. And we agree it should be at the date.
Do you agree the distinction between triviality and materiality?
We say it must, in all cases, and this is something that's carried on through all the cases, it must be material for it to be assessed side. Triviality is always going to be immaterial. But
if it's not trivial, is it material? I think that's what Lord Justice Briggs was suggesting. In other words, the two, as my lady I think was raising with you, the two contrasting positions you have. If it's trivial, it's not material. But if it isn't trivial, it is material.
Yes, and we say it's not as fine a distinction as that.
Right.
The question is, as is said throughout all the cases, is it material? When it is trivial, it is obviously not material. But there is a grey area in between the two, where it might be said to be of some substance, but it would have made no difference at all. And those cases exist. It might be said, this case is one of those cases, but I'm going to come back to why the non-disclosure in this case was not, on any view, substantial, and would not have impacted on the wife in any event. But to simply say it's only trivial non-disclosure that counts, we would have to disagree with that, and we don't read Lord Justice Briggs as saying that.
Do we have Lord Justice Briggs's judgment?
We do not. Okay. We have Baroness Hale's later commentary on it, which I was going to return to. Baroness Hale then continues to say, in respect of her second part, that the husband should not be allowed to hold on to an order tainted by material fraud on his part by rearranging his affairs so as to bring them broadly into line, but after the event, with the false picture originally portrayed by him. Third, the wife had been deprived of a full hearing of her claim. The purpose of the hearing in April 2013 was not to determine her claim, but only to decide whether the order should be set aside and a rehearing ordered. And then it was said cross-examination was unnecessary and so on. This is then developed by Baroness Hale into her summary, which is at paragraph 32, which is on Authorities Bundle, page 1413, or on the report of the case, page 884, at letter D. My little friends pray and aid heavily paragraph 32, and we say they need to carry on to paragraph 33, that they are, of course, significant, and must be, we say, read together. The first part is that there's no need for us to decide in this case whether the greater flexibility which the court now has in case of innocent or negligent misrepresentation in contract should also apply to innocent or negligent misrepresentation. And then the next sentence. It is clear from Dietz and Livesey that the misrepresentation or non-disclosure must be material to the decision that the court made at the time. And we respectfully say that has to be the test, that must be the test. Was it material? Any attempts to paint around that are unhelpful, particularly in an area of law which is so variable as financial remedies are. Materiality is all. It goes on to say, but this is a case of fraud. And just pausing there, my own friends described this case as a case of fraud. That's not how the judge described it. And we would take issue with that, but we do accept there's non-disclosure, but nothing turns on that for the purposes of the appeal today. In any event, Baroness Hale continues, it would be extraordinary if the victim of a fraudulent misrepresentation, which has led her to compromise her claim to financial remedies in a matrimonial case, were in a worse position than the victim of a fraudulent misrepresentation in an ordinary contract case, including a contract settler claim. As was held in Smith and Kay, a party has practiced deception with a view to a particular end, which has been attained by it, cannot be allowed to deny its materiality. Now, of course, that's the part that my learned friends rely on most heavily. But there's an element of circularity in it, because it doesn't become non-disclosure of a type which enables an order to be set aside until the materiality is established. And that is the view which is then developed by, we say, Baroness Hale thereafter. She continues, furthermore, the court is in no position to protect the victim from the deception or to conduct his statutory duties properly, because the court too has been deceived. In my view, Lord Justice Briggs was correct in the first of the three reasons he gave for setting aside the order, which were the reasons we turned to a moment ago. The general principle of fraud unravelling matters. And then paragraph 33, which we say is the most important paragraph. The only exception is where the court is satisfied that at the time when it made the consent order, the fraud would not have influenced a reasonable person to agree to it, nor, had it known then what it knows now, would the court have made a significantly different order, whether or not the parties had agreed to it. But in my view, the burden of satisfying the court of that must lie with the perpetrator of the fraud. It was wrong in this case to place on the victim the burden of showing that it would have made a difference. We accept that burden, and what we say is the Deputy High Court Judge was too quick to, having established non-disclosure, assume, well, we're talking about some large numbers here, so we can then move to a position whereby it is said that the materiality is established. Because an analysis of what took place reveals a number of misunderstandings as to what took place. And if we may, my lords and my lady, look at the judgment itself, we have at paragraph 64, which is at page 133 of the core bundle, we have the learned judge's analysis of the materiality argument, and he deals with it very briefly. And it does require some explanation.
Sorry, can you read it again?
Certainly, it's paragraph 64, page 133 of core bundle 1.
Thank you. Yes.
And what he is saying there is, having reached a conclusion on non-disclosure, he says, it prima facie follows that I should set aside the consent order on the grounds of material non-disclosure. Well, it doesn't prima facie follow that because non-disclosure is established, that materiality is also established. It may well be that the burden is on us, but that's not the same as saying that we're starting from this position. That is the first, we said, the misunderstanding as to the approach. And he says, on the basis that husband should have informed the wife of this development, i.e. what he knew about the intervenor's intentions in July of 2021. That's very important, because a common error in my learned friend's skeleton argument is they keep referring to the non-disclosure of the gift. There was no non-disclosure of a gift in March of 2022. There was non-disclosure of a stated intention to make a gift which would not be made if the wife was to benefit from it. That's what was not disclosed. And that's very important, because he needed to find that level of what was actually not disclosed. Because all of the evidence made it quite clear, and I don't want to trawl through all of that again, because it was all summed up by the deputy judge in terms of the relationship was one of hate between the parents and their, not just parents, siblings on the one side and the daughter on the other. There was no possibility that they would have wanted this to go ahead. Indeed, the whole of the wife's case was the reason why, and as was found by the judge, the reason why this wasn't disclosed was, in the memorable phrase, to wait until the coast was clear, i.e. to make sure that the wife should not benefit from this gift. So this is not like one of those cases where a husband has non-disclosed assets in a Swiss bank account, or that he's about to do something with his company which is radically going to alter its value. It's nothing like that at all. It's in respect of a third party who's made it absolutely clear that if there's a danger that their much disliked daughter is going to benefit, then it's not going to happen. And the context of that was very important, and that's why we spent so much time on that. In the context of the 670 million fraud that was perpetrated by Ernest de la Sala against his brother, what the wife did was beyond unconscionable. And the wife accepted this in her evidence. We can turn to it if need be in the cross-examination. What she did was she went to the other side and she offered a deal. The case concerned a company suing for the recovery of those sums of money, and the sums varied between 670 million and 800 million. The company was suing for the recovery of those. She went to the other side in that litigation, Ernest, and she said, I will support you. That would have meant that the board would have lost control. That would have meant that they couldn't have continued with their action. That would have ruined her father and her mother. It's as simple as that. And in return for that, the wife hoped to get $20 million. That was what her father described as the ultimate betrayal. It describes the level of animus. And it's in the context of that the non-disclosure is, I'm going to make you a gift, but not if my daughter, who tried to ruin us recently, who we've sued, who's caused their granddaughter to be put in prison, and all those details that are referred to in the closing notes. If she's going to benefit, it's not going to happen.
If we look at the findings that the judge actually made, I think that first of all in 61 and 62, 62 he says he's reached the clear conclusion that the husband acquired knowledge long before March 22, and I think he's saying at least by July 21, that he knew that he was likely to receive a substantial gift of money, and he knew the likely size of the first part of it, namely 20 million Australian dollars. So, knew was going to get a gift of approximately $20 million. And then if you look at 63(2) at the end, it's clear from the all oral evidence before me that the dominant motive at the time, and what he's talking about then, is not 2021, but I think 2022. The dominant motive at the time was a fear that the wife would cause trouble when she found out about the gift, and there was a question of postponing the gift to a time when the coast was clear, not cancelling it altogether. Those are the judge's findings.
Yes.
Not that the gift would be cancelled, but postponing it to a time when it was thought, I'm interpolating, the coast was clear.
Well, first of all, that finding must relate back to possibly 2020/2021, certainly from 2021. Because if one looks at paragraph 62, he's
Yes, all I'm referring to is those were the judge's findings.
yes,
That I know I'm going to get a gift. The first tranche is going to be 20 million. The precise timing of it, payment of it, is going to be postponed until we think the coast is clear. We're not cancelling it altogether. So that's the finding that you have to address, not the submissions you were making, but the findings made by the judge.
yes. Well, the postponement is not in any way time described. A postponement could carry on for years and years and years, during which time the husband continues to work in that family business, the Manors business, however it's carried on. There's no limit on postponement. What the motivation behind that postponement is carries on for as long as they think there is a danger that the hated daughter is going to benefit from it. And so the postponement could be for so long that it carries on so that it goes to Mr. Copinger-Symes' children, for example.
Where's the judge's finding of that?
Well, he just says postponement.
Yes. Until the coast is clear.
Yes, and that means until the coast being clear is the moment at which the wife can no longer claim against it. That's what coast being clear must be. So they're going to postpone it and keep postponing it until it is not subject to a claim by the wife.
Can I put it? Sorry, go on.
Because that's not actually what the judge found. The judge is here addressing the motive that he found for postponing it in March. We know, in fact, it was later given, not that long afterwards. So the judge does not find that the intention was to postpone it forever, if necessary. He just says the motive for postponing it in March was that it was being postponed to a time when the case was clear. That's all he's found.
Well, the motive, which goes back to the earlier parts of the judgment and the findings of the level of animus that were between the intervenors and the wife, go to them wrongly believing, it seems, that they would be free of further actions and claims if they were to postpone at a particular moment in time. What that defines is what they had in mind in March of 2022. So what they had in mind of March 2022 was, we're not going to pay this until the coast is clear. That's their state of mind, and that's what the judge finds. If it had been the case that they had understood that if they were to pay the money in 5 years or 10 years or whatever the case may be, then it sounds as if, from what the judge found, that they would have postponed until then. But as it was, they seem to have believed that the coast was clear sooner. This litigation proves they were mistaken in thinking that would see an end to the litigation. But the finding is they would postpone it for as long as it would take. So a judge looking at this, and we say this is what we have to do. We have to go back to what Deputy District Judge Smith was doing and say, if Deputy District Judge Smith had been told there is this enormous wealth in the background, something which the wife well knew, that there is the prospect that the husband is going to get a great deal of money for him.
Well, addressing, as my lord said, the actual findings of the judge,
Well,
the husband knows that it is likely he will receive 20 million Australian dollars. That's a much more precise fact that's not disclosed than
Yes.
just there is wealth and it's likely he'll get, there's a prospect he'll get something. In March 2022, when they were in front of District Judge Smith, that's what the judge found the husband knew. It was likely he was going to get the first tranche of 20 million.
yes, but it does need the caveat at the end, which is, but that money will be postponed until such time as it can be put out of the reach of the wife. That's
Can I?
the point of. Otherwise, the case won't be clear. So
I go back to another point, which is paragraph 64 and 65. Were you looking at how the judge dealt with it? You said the judge was wrong to say that the prima facie position, I now can't find it, but the prima facie follows.
Top paragraph 64.
Prima facie follows. And in addressing that, you treated the question of whether there was material non-disclosure as the same question as to whether it would have made a substantial difference to the order. Have I understood that correctly?
I'm treating the materiality as it would make a substantial difference, yes.
Well, I don't think that's what the judge meant. I don't think it's what Baroness Hale meant and Charlotte. I think if you go back to Livesey and Jenkins, there's two questions. The first question is, should something have been disclosed? That's a question of materiality. You don't have to disclose things which are immaterial. This is a very familiar principle from other areas of law.
Yes, I agree with you. Yes.
What full and frank disclosure requires is disclosure of matters that are material. And things that are material are things the court deserves to know, aren't they? And surely the assets available or in prospect to one of the parties is something the court needs to know. So that's what materiality goes to. And that's where, if it's, as I understand it, if it's a £10 in a bank account, it's not material. Then it's a second question addressed as a second question in Livesey and Jenkins, and it's a second question addressed by Baroness Hale and Charlotte, whether, given that there is material non-disclosure, nevertheless, you can escape the consequences of your material non-disclosure by showing, the onus being on you, that it wouldn't have made any substantial difference. And that seems to me, that question, would it have made any substantial difference, is a separate question from, was the non-disclosure material? And you've conflated the two as if they're the same question. And it's not obvious to me that they are.
Well, Lord, first of all, I entirely agree with your Lordship's analysis. That entirely accords with my analysis too. What I was suggesting was that the learned judge conflated the two.
Well, I don't think he does. I think he finds material non-disclosure because knowing that you're about to receive or likely to receive a very large amount of money is something material that the court ought to know. Then he says it prima facie follows it should be set aside. That's because the onus is on you to show that it wouldn't have made any difference.
Yes.
So unless you show that, it falls to be set aside. And that's all he means by saying it prima facie follows. And then he goes on and addresses the question whether you've discharged that onus. Now, is there anything wrong with that way of looking at it? Because at the moment, this seems to be in line with the authorities.
If your Lordship takes that view, then that is the same view of our analysis of how it's dealt with, the two-stage test, the one of looking at the materiality of the original disclosure and then whether or not it's had a substantial impact. We read this as saying that the second of those simply follows into the first. If your Lordship doesn't read it that way, then I don't wish to take a bad point and I'll move on. Okay. The point about whether matters should be disclosed is, of course, fundamental to what is already known at that time. And
well, you don't have to disclose something if someone knows it already.
You don't have to disclose something if it's already well known. No.
Did the wife know that the husband had already learned that he was likely to receive $20 million?
The wife already knew that the husband was going to receive very, very substantial payments from her family.
Is that the same thing? It's not the same thing, is it? I mean, to know in general terms, suppose, take a case of a company which is privately owned, and the wife knows that the husband intends to have an IPO when he can in the short to medium future. That's different from knowing that he's already given instructions for an IPO next March. They're different levels of specificity, and one would have thought that when you have to fill in your Form E saying what are your assets, it's not enough to say, well, she knows I've got a house in France. You have to say, this is what I own, and this is what it's worth, and so on and so forth.
Yes, but that's not this case.
What is the difference between saying, I know that there's a lot of wealth and that my husband might in due course get some of it, and knowing that the husband has been led to believe he's going to get a first tranche of 20 million when he can.
Because she already believed, though, and I'm going to come to this, she already knew that he was going to get specific sums of money which were in an order of magnitude of millions.
Okay.
And so it becomes a question of, well, how is it received? Would that really have made any difference, first of all, to her thinking? Because her whole grievance...
No, but you've tripped again into, does it make any difference? Whereas what I'm trying to focus on is, was it material non-disclosure in the sense that it's something that should have been disclosed, which the wife didn't already know? And you said it, but the wife already knows it. But it's not obvious to me that the wife knew what the husband knew. And if the wife didn't know it, the court didn't know it.
It becomes a fine difference and a distinction without significance between knowing that someone is going to benefit to the tune of tens of millions and knowing that that person has said, I'm going to pay you tens of millions.
I see. Okay.
In both of those cases, with the caveat that the planning of it would be to postpone it until such time as the wife could not benefit from it. And that would be very much in the donor's intention. And the example that's given there of the £10 in a bank account would not be non-disclosure. That was the subject of some discussion in closing. The £10 would be, we're all agreed, it would be a trivial sum of money, overlooked in a forgotten building society account. That would not be something that would enable someone to go and set aside an order. But on the facts of this case, that's what would have happened, because the postponement would have lasted until such time as the coast is clear, which means that if the coast is never clear, the postponement is infinite, potentially.
Sorry, I don't understand that.
No.
At some point, there's going to be a resolution of the financial remedy claims.
Yes.
The court will take into account the evidence. The evidence, you're speculating, but the evidence might be, I intend to give the husband $20 million or $40 million, but I'm not going to pay any of it until the financial remedy claims are settled.
Well, it's more than that. It's, I'm going to postpone the payment of it for so long as I think the wife might benefit from it.
But what does that mean?
Well, that means it could be postponed forever.
Well, how are you going to decide once the financial remedy claims are settled? How's the wife going to benefit from it?
Well, for example, she can apply, as she has done, to set aside the order, or she could say it's a
But
bar
if there's
event,
been full
as
and
she
frank
did do.
disclosure, let's predicate full and frank disclosure.
Yes,
That included, I've been told I'm going to get $20 million.
yes.
I've been told I'm going to get another 20 million, say, is not going to be paid until the wife's mother is satisfied that it won't, in some way, inchoate, benefit. Court will take that into account and make its order.
Yes.
What then happens?
If the wife were to persuade the court that it should proceed on the basis of the gift is as good
A
as done,
potential gift.
the potential gift
Yes.
is completed, then in those circumstances the gift would not happen, and that's why it becomes valueless.
Sorry, I don't understand that. Where's the evidence of that?
Well, that's the whole point about
The court makes an order.
the court.
The court makes an order. The wife keeps all the assets. What then happens? No
Well,
payment.
Well, the wife's case is not that she should just keep all the assets. The wife's
Yeah,
case is
but that could be an
she should keep
outcome.
the assets and she also gets part
I
of the
know. But
gift.
what I'm asking you, if that was the order, what's the outcome? Where's you're saying still never paid, even though there's been a final resolution of the wife's claims.
Well,
The coast is clear.
Well, it depends on whether the coast is clear, because the wife's case is, and the one that we're still answering, is she should be getting part of the gift as.
I understand that, but that's not what I'm trying to work out from your submissions is how it actually works. We've had full and frank disclosure that your client gives to be blunt, the honest position, which is, I've been told this. Your case is that the wife's mother would give evidence, I'm not going to actually pay it until I'm satisfied that the wife won't benefit from it. What's the court going to make of that when it makes its decision?
We say it's going to ignore it.
Why?
Because
Why on earth should it ignore it?
because it won't happen, my lady. It won't happen if the court does make
They might not believe the mother.
Well, that's something which is improbable in circumstances where it's easy for her to rearrange the affairs so that there isn't a straightforward lump sum. For example, she could pay for holidays for the husband. She could give money to the
Then he's
grandchildren.
still financially benefiting from the money, isn't he?
Well, that was always known. It was fundamental to the wife's case, and the reason why she gets 81%. It's expressly said before Deputy District Judge Smith that one of the reasons why they're departing from equality is because the husband is going to benefit in the future. And so, to answer my Lord's question, what happens is we go before Deputy District Judge Smith. We say to Deputy District Judge Smith, as the wife has asserted for 2 years now, the husband is going to benefit from the enormous fortune that the wife's family have, her extended family have. We now know there are some dates on which some of that money might come through. The wife has made some suggestions as to when she thought that money would come through. She gives figures of 7 million a year, for example. $7 million US a year is one example that she says that she's expecting. That's now happening. What difference could that make? Yes, well, we can deal with it analytically. We can deal with it in accordance with the classic three strands. No one's talked about compensation. It then comes up in, would the wife have a share in respect of any of that money? No, obviously not. It's plainly non-matrimonial. It's 6 years after the marriage has effectively ended. Arguably longer, because the date of separation takes place at a time when the parties have already been living in different places. So it's not going to be a sharing case. Is it part of the wife's needs case? And again, it patently is not going to be part of the wife's needs case because her needs are not informed by any extra money coming into the husband's world. Any
Does
more
it
of them.
affect the husband's needs case?
Well, the husband's needs case, it's not just a question of his needs also. It's also an element of, contrary to what my learned friends say, he would have had his own sharing case too. For example, money was in a matrimonial home which he contributed to. He brought £500,000 to this marriage.
But my Lord's question is, does it affect your client's needs case?
I thought your case
The
was a
answer
needs
is
case.
no.
I thought your case was a needs case.
Well, that's how it's described before the Deputy District
Yes.
Judge by the wife on the basis of, well, it meets his housing need, and then it's assumed in respect of his
So
income.
presumably the Deputy District Judge proceeded on the basis that what he was approving was something that met your client's needs.
Yes, but it wasn't just the capital that he was getting. It wasn't like a capitalised maintenance. So the capital he was getting met his housing need. Then he was going to carry on working with the De La Salle family to meet his own income needs. That was the presentation for the Deputy District Judge. So part of it was he was going to carry on having those earnings.
But coming back to my Lord's question, would this fact potentially affect your client's needs case?
No, because the money would be postponed, potentially ad infinitum, if there was a risk that the wife would have benefited, which she could have done if the husband was to get a lesser reward and she was therefore to get a greater reward, which is what she was contending for.
Where's the evidence of that?
Well, quite.
Was that ever anybody's case? That I'm not going to give you this money, even if you keep the whole 40 million, but it affects the amount that the wife gets of the existing assets. Is that your case? Was that ever anybody's case?
I'm sorry, I didn't quite follow my Lord's point.
Well, I thought your case was the mother wouldn't give the money to the husband if there was any risk that money could be shared with the wife. Is that not your case?
It is, but it goes further than that.
You say it goes further than that. So,
So
the money would not have been given to the husband, even if he kept every cent of it, but it affected the split of the existing assets. Is that your case?
Yes, because
Where's the evidence?
because they didn't want her. It's
Where's the evidence of that?
They didn't want her to benefit.
Benefit from it is what I
Benefit
thought.
from the gift, not benefit.
Yes, but that's benefit. But
That's a benefit from the gift, is it?
Yes. Yes. My left hand's helpfully referring me to page 79
Of
the supplemental bundle.
'79.
Yes, page 79.
Thank
and
you.
This is from the witness statement of the intervenor.
Yes.
It's paragraph 4. So, in answer to my Lord's question, the evidence is this. The basis of the application is Bob and I would never have given James money if we thought there was any possibility that Christina could benefit from it.
Yeah, from that money.
No.
That's plainly what it means.
It carries
Get
on.
benefit from that gift.
It's
Carry on. It went without saying, if he were to receive such a gift, it, that is the gift, was not to be used to benefit Christina in any way. Neither of us would have contemplated making the gifts if we thought there was any possibility it would benefit as a result.
yes, result. That's the point, my lady.
But, I mean, you're trying to read that like a pleading.
I'm not, my lady.
The obvious intention is we're not going to give this money to James if Christina's going to get any part of that money.
No, my lady, it is not. What is clear from this, and the word result there, is that if Christina is going to get any benefit as a consequence of their largesse, then they don't want to do it. They don't want to see her one penny better off. It's hard to understate the level of animus that there is within this case between.
But sorry, this is before the order's made.
Yes, there's already that level of animus.
What?
Before the.
No, before the order is made. The order hasn't yet been made.
Yes.
So the court takes it into account. How do you know the extent to which the wife has or hasn't benefited from the existence of this prospective gift?
Well, because it's being said by the donor, if there's any chance of the wife resulting in getting any sort of benefit from it, then I'm going to either infinitely postpone or simply not make the gift.
Right, okay.
Because that was her.
And as my lady said, that would be an issue that no doubt would have to have been addressed in a trial or at a hearing if that was the case that was being advanced.
Well, that was consistently our case. We were certainly advancing that there would have been no gift if there was any benefit at all to the wife.
Right.
And that is entirely in keeping with the enormous history of this case and the level of unhappiness that there was.
So benefit includes the court taking it into account when making its order.
Yes, and that's unequivocally at page 79 where it says, it went without saying that if he would receive such a gift, it was not to be used to benefit Christina in any way. Well, she would have benefited if she had got more money from the financial...
It was not to be used.
It was not to be used to benefit Christine. Well, she would be benefiting.
It would be used to benefit her if she was benefiting from a court order. It wouldn't be relating to that gift.
But she would only benefit from the court order if that gift came into play.
I know,
So
but the obvious sense of this, I'm sorry to keep on about it, but it just seems to me the obvious sense of this is we're not going to give the money if that money's going to be used for her. I can't see it means anything more than that.
Well, my lady, with respect, that's
I know it's not your case. I'm just saying that on the evidence, that's not how I read it.
Well, that's not how Christina gave her. How Tyrrell gave her evidence either. There was no suggestion of, oh, it's only the gift that I don't want to have taken into account, and it would be slightly unreal to think that she could give a great deal of money and then tangentially Christina benefits to the tune of, say, £1 million, whatever the figure is, when the whole point of not giving the gift was to make sure that Christina did not benefit at all.
Don't forget, you're still dealing with the material point, and I think you were going to deal with the position about what you say the wife, because you said she already knew that the husband was going to get specific sums of the order of magnitude of millions. And I think you were going to deal with that.
Yes.
I just don't want you to lose your position in your submissions.
My lord, I can move to that.
But don't move. I mean, I was just going back to that because we asked questions after that, which might have distracted you.
Well, my lord,
no, not at all.
it might be assistance. So to pick up that point whilst we're there and whilst we have that bundle open, if your lordships could perhaps turn to page 107 in the same bundle.
$107.
Yes, please.
Thank you. Yes.
This is the very lengthy witness statement of the wife dealing with. It's a 59-page statement of 14th September 2023, and here she's dealing with part of her claim, which is that she was saying that the husband was going to be very substantially benefiting in the future, and that he was that was her expectation. And what she says is the sums received in 2019 were challenged by James at the time. That was some money that both the husband and wife were paid. Lawyers advised us not to be greedy given the ongoing court proceedings. The sums were unrelated to the expected compensation for our involvement in the recovery of 600 to 800 million of assets, as we were all very aware of at the time. Indeed, per Edward's statement, paragraph 55, the fruits for ECJ for the company's litigation would be the recovery and management of the assets, and this was expected to be 10% of the profits on 700 million, which she thought would be about 7 million a year. Now, the wife's case in respect to that does move around a bit.
Sorry, is that for Edward, Christina and Jane?
No, it's just so
How does that work?
they get 10% each. So 700 million generates 70 million. 10% goes to the husband, 10% goes to Edward.
Sorry, I don't understand that.
What the wife expected would happen is that the funds under management would be allocated so that 10% would be given over to the husband. It's perhaps clearer in the wife's. It's not a great deal clearer, but it is perhaps clearer.
So 30% would be distributed between the three of them, you're saying?
Well, I'm not sure that. I think the wife might have been saying the 10% should have been split between her and.
Maybe we should see Edward's statement at paragraph 55, because that's what she's cross-referring to.
Yes, and that says 10% to him, 10% to the husband. What reference? Yeah, no, I've got that. So, page 417 and supplementary bundle 2. The wife is asked.
Sorry, page what?
Well, it's perhaps in the interest of time, if we went 418.
Sorry, I didn't hear.
Sorry, supplementary bundle paragraph, page 418.
418, thank you. What?
This is evidence.
So this is the wife giving evidence at this stage.
Yes.
And the wife's dealing with her knowledge at the time. And she's being asked about the money that's expected to come in the future. And she's being asked about how they're going to be benefit. And then she's asked just below letter D, she's asked, in the context of hundreds of millions, what did you expect the benefit to be? and the wife says, "My lord, I think I've explained already that I didn't believe these loans he was getting from my family were going to be called. So he'd get them. So she expected the loans to be forgiven. That's the system that's always been adopted in the past. I think he would have also got the earnings on the company, which I had set out were 10%. So he was going to be well looked after. They, of course, denied it. Hannah had said, no, not happening. What is well looked after? As she's asked, how much is that? She says, well, 10% of whatever profit you get from whatever you're managing. Then put to her, well, you thought it was 800 million he'd be managing. She says it wasn't.
Profit. That's not the same as 10% of the amount that's being managed.
No, so what it is she expected there to be 10% profit on 800 million, which is 80 million, and then 10% would be the husband's share of 80 million. This was her expectation. And and that's developed over the page. So I put to her as 800 million. She says no. I asked how much was it, and she says, well, hang on, sorry, it was 800 million, but that was all frozen. We weren't earning any money on that then. So we come back to, well, it's 800 million, which we see at the bottom. If we were managing 800 million, then if we earned whatever profit we earned from that, we would get 10% of it. How much do you think would be managed? 800 million. So if you had, let us say, you would agree, you're making 10%, it would be 80 million. So you get 10% of that, you get 8 million. Yes.
That was the wife's case. Was that agreed?
It
The
was.
wife says, she says it's disputed.
It was disputed.
Right.
It was the way that the husband was going to benefit was not something even now that is fully known to the husband because it's in the gift of other people. So certainly the wife's understanding was that he would be getting that 10%, and then Edward would be getting his 10%.
I know, but that, as you will know from another things, Go Hill, you can't say an applicant is not prohibited from developing an argument by, in Go Hill, I think the recital was, the wife said, I don't believe the husband's disclosure, but I'm going to settle the case anyway. And that was said to prohibit or bar the wife from bringing a case on non-disclosure. And as you'll know, the Supreme Court said no, you can't deny your obligation to give full and frank disclosure because the other party suspects that you haven't.
Yeah.
So this is a dispute. There's an issue as to what you've just said. There was a dispute as to the way in which the husband was going to benefit, and he didn't know.
Well, he did know he would benefit. It's the specificity.
It's the how.
Quite. Thank you, my lady. It's the how. And that then becomes a question of, well, is this truly then a lady who has been misled in circumstances where she knows there are hundreds of millions potentially available? She has an expectation that that's going to be divided into 4 parts. Her great complaint is that her quarter of that fortune is not going to her, it's going to her husband. All of that is known before March of 2022.
I'm sorry to pick you up. I think that's the wrong way around. It's not was she misled. It's did your client fail to give material disclosure?
Yes. And the answer to that is, was it material in regards to how it affected the wife's knowledge of how it was he was going to get the money? Now, she thought he was going to get the money via annual payments that could have been 8 million a year. And in Singapore, I assume that would have been effectively tax-free.
But he denied it.
But he said, no, I don't think I'm going that way. But he didn't deny he was going to benefit.
I'm sorry, Mr. Todd, I missed that. Why do you assume it would be tax-free?
Because that's the way the parties were organising their financial affairs vis-a-vis.
He gets an income of 8 million, he doesn't pay any tax on it anywhere?
I would need to go back to review what the Fisher report said in respect to that. But certainly there was a great deal of tax efficiency involved in Singapore.
Okay.
Could you just help me, in these figures, what currency are the figures being...
US dollars.
Thank you. Yes.
And so I was just looking
So that's materiality.
yes, so in the context of what was it that the wife was misled in respect of, and it's simply the question of how was he to benefit from this. Throughout, the wife knows what is coming to the husband, and that informs how she deals with matters, and indeed how matters are resolved before the Deputy District Judge. My lords, my lady, if I may, if we can look at the note which the wife disavowed herself of, but which the learned judge rejected her evidence of, which is the note that was put before the Deputy District Judge Andrew Todd on the 27th of July of 2020, which is in supplemental bundle at page 3. This is a note by leading counsel, one of the leading counsel that the wife was retaining, Miss Deborah Bangay, King's Counsel. I think then Queen's Counsel. And this note is important for setting out the wife's state of knowledge and also what she was contending. Some of what she says is controversial. The first point in paragraph 2 at page 3 is she says all the assets emanate from wife's exceptionally wealthy family. Well, that's actually factually wrong. And not only did the husband put in £500,000, but the French property, which then becomes the seed capital to one of the Marlborough Road properties, that comes from the husband as well. It's not right that he has a sharing case. It's not the case that there is no marital request. And of course, the parties worked during the marriage, and that money went into their finances in any event. But in any event, she describes already by then the degree of hostility which exists between the wife and her parents, including that she's currently engaged in litigation with her father.
Sorry, where are you?
Sorry. So at the bottom of page 3, at paragraph 3.
Oh, sorry. Thank you.
So paragraph 2 is about this all comes to marital request, which we don't agree with. But the next part, paragraph 3, describes the fact that there is this litigation with the father. But that also takes place in the context, and this is one of the 4 issues I'm going to end with, and when I come to them, is in respect of income and needs. She already, in paragraph 4, we can see, knows that whatever income there is to be from the Manors company is far from secure. And it's said there that the wife's in an invidious and precarious position, and then worse, she remains dependent on her income from the family company, £6,000 a month, which is far from secure, having regard to the cabal weighted against her. Paragraph 7, there's reference again to the antipathy of the wife's family. The wife believes that this is encouraged by the husband. Well, that was controversial, and the wife didn't get home in respect of that, but there being a long history of animus, probably nothing turns on it, but the fact of the antipathy is already well established there. And then she refers to the background wealth and expectations. And paragraph 8 says, these proceedings also been long delayed since wife's Form A in 2018, as they awaited the outcome of the proceedings involving the De La Sala family companies in Singapore. So the proceedings themselves are waiting to see what's happening there. That's how front and centre this is. These last from 2011 to 2020 and pertain to the removal of $670 million from the family businesses as a result of Ernest's fraudulent misrepresentation. The net effect of those proceedings was that Ernest lost and the generation above wife benefited, although she and the husband were entitled to a substantial payback from the business. And then they said, and possibly damages. And then this significant paragraph 9 on page 5. all this makes for a toxic backdrop when addressing the issues in this case and husbands' needs-based claims. Now, pausing there, there's no suggestion at any stage of the wife's needs being not met by the provision that she agrees to a clean break in respect of in her order. The wife's contention is it's needs-based in respect of the husband. And she goes on to say, but that is impacted because, and this is a quotation, having been supplanted by H in her parents' affections and her position in her family, wife has no doubt that husband will, as he does to a lesser extent at present, continue to benefit from the largesse and wealth once these proceedings are over, whilst she will not. It's then the complaint is one of how it is that he is to get that largesse. Should he be getting it by way of 8 million a year, as the wife suspects the case is, or should he be getting it by 2 large lump sums, as turns out to be the case? It doesn't impact on the wife's knowledge or how she believes the case is going forwards. And in this case, it is significant that her whole focus, which was not accepted by the judge, was that somehow there was some kind of entitlement by her, which was rightly rejected. The position then is she knows about these third-party people. She knows that there's a great deal of animus in respect to them. It's not a very long walk to go from there being this level of animosity to the next stage of there being a desire by those people not to gift her or in any other way cause her to be enriched as a result of any action that they take on their part. And that was what was said in respect of the statements. The page 11 of the Supplementary Bundle 1, Ms. Bangay, then Queen's Counsel, says, in respect of the case, that she identifies the husband's claims as simply a needs claim for a house, and then says this: it is plain he has no maintenance claims as he has an assured income for life. Well, that's that 7 million or 4 million or 8 million, whichever figure that the vagaries of the market might determine it should be, which is going to be available to the wife, sorry, to the husband from the wife's extended family. It's an assured income. She knows that. And then there's also then the question of soft loan, which again, not been any demands for repayment, and the wife's expectation is that it's not going to be called in. Something which the husband's also of that view. And then paragraph 53, we have this: no doubt, once these proceedings are over, he will be handsomely repaid for his loyalty to wife's family. So in her mind, there's no doubt about this at all. And what's handsome reward to people who have 670 or 800 million US dollars?
Was that accepted?
It was what accepted?
Was your client's case that he expected to be handsomely repaid for his loyalty once the proceedings were over?
He did expect to benefit from the wife's family.
Where's his case?
Well,
shown us the wife's case. I think it'd be interesting to see what his case was.
Well, his case was he was going to expect to benefit from the wife's family. He didn't know to what extent, but he knew he was going to carry on the business.
Can you show us where it is?
Yes, I might have to come back to you with a reference in respect to that. I will come back to a reference in respect to that, and of course that's
and
also.
You said several times that it was the wife's saying that the husband's case was a needs claim. Likewise, I think it'd be interesting to see, helpful to see, how it was put on behalf of your client at that time.
Yes.
When don't necessarily deal with it now, but at some point it would be helpful.
Yes.
Maybe we don't, because we only have one. We have somebody else. We only seem to have one note.
We do. We've only got Ms. Banger's note. We don't have
Right,
Mr.
okay.
Richard Giles's note from that hearing. And that's because that was the one that's referred to in the Deputy High Court Judge's judgment, where he refers to what's being said in respect of expectation. I see. No. So we're going to locate that reference.
Thank you.
My Lord,
Perhaps while we're about it, we should have the whole position statement on behalf of your. What was this for? Was this for? This was for a hearing in July 2020.
it was before District Judge Andrew Todd.
Yes.
Yes. You want the position statement from the husband?
Well, it'd be interesting to see. You know, what you were
Certainly.
showing us one side. I think it'd be only fair to look at both sides.
Yes. We'll locate that. We'll find that.
Thank you.
That was not at the hearing below, but we will
I understand
locate
that.
it.
Yeah.
Yes. And allied to that, sorry to jump to the other bundle. Sorry to jump further into the bundle. At page 105.
Yes.
We have a further description, which I think slightly deals with your lordship's question, and that is in respect of he had a hope that he would benefit.
Sorry, which paragraph?
It's at page 105, and it's paragraph 69.
Thank you.
This is the wife's statement.
This is the wife's statement.
Yeah.
It's at paragraph 69, and she is referring to the statement. Yeah, where she says, I've dealt with James's asserted hope that he might benefit from share of the profits above. That's where he might get a share of the money from there. And he says, as advised, despite my concern, James never asserted in divorce negotiation that he would earn large amounts of money from my family as well. So that's what the wife's case, about what the husband's case was.
Right.
She then goes on to say, I accept, although this is somewhat a distraction, that the 10% profits, etc., could be in the region of £4 million a year is optimistic. That's what she'd said previously, that she thought he was going to be getting £4 million a year profit. And now she's saying, in circumstances where there have already been a number of distributions, for $40 million US each, and that would have been, of course, times 4, and that a more accurate calculation would be 240 million available. And there we see the 10% profit that was expected. So therefore, after those distributions, 2.4 million a year. And just says in line with historic payments and to avoid tax. These would be likely to be made as gift distributions. I think that's where I got my reference to the trying to avoid tax from.
Right. Thank you.
So it's a case of the wife not only knows that or believes that the husband is going to get these very substantial sums of money, but also, right at the end of paragraph 70, well, they might be paid by way of a gift because that's tax efficient. And that's what happens. So what happens?
Are you pinning it on knows or believes? Because you said no or believes.
Well,
There's
it's
a difference between knows or believes.
well
So I'm just wondering
in the
which-
wife's case, she elevates belief to this.
So what's your case? That she knew or believed? Your submission was knows or believes.
Yes.
I think there's a
She
difference.
she certainly believes because she says that.
But what's your submission? That's all I'm trying to ask you.
Well, her knowledge is incorrect because that's not what happens. he doesn't then get 10% of the profit.
So this is with the wife's belief.
It's her belief.
Right.
So she's mistaken as to how the husband is going to get the money, but she's not mistaken that he is going to get the money.
The money.
Yes, i.e. the money that is coming from the extended De La Sala family. So her belief was it's going to be paid as up to $8 million a year. But she then qualifies that to say, to avoid tax, it's going to be made as a gift distributions.
So she's mistaken as to how, but not that. And is she mistaken as to amount?
Well, she comes in too high. Because if it's the 8 million that's referred to in cross-examination, then it doesn't take very long to dwarf the figures which the husband is actually being paid.
Right. Thank you.
I mean, and we are talking about, from the wife's point of view, that this was going to be a payment that was going to carry on for all practical purposes for as long as the husband is still with us.
Do we have the husband's statement that this is responding to?
I don't think that made it. We had nearly 7,000 pages in the court below, and there had to be quite a fierce weeding process. So
I understand.
I don't think the James statement made it. Instead, what made him was the points of claim, which set very shortly. It's simply his position in respect of the gift itself.
Yes, thank you.
But the gist of it is certainly described there in the wife's statement in reply to that. So when it comes to a question of knowledge, the wife had also been describing in her Form E, as is referred to in the hearing before the learned Deputy High Court Judge, to a background wealth running into the hundreds and hundreds of millions.
Sorry, also had what?
The background of where she's describing the family wealth as being 800 million. That came from her original Form E. She then tried to row back on it. The judge didn't accept her evidence about that. Whatever number of hundreds of millions it is, and it speaks volumes that we're not even putting a figure on whether it's 670 million or 800 million, or even as low as 400 million. But in each case, it was always the wife's firm belief, and therefore her basis for her rationale for entering into any discussions, that money was going to be divided in stirpies between the 4 children. And indeed, that is the fundamental part of the case which she's still pursuing as we speak in the New South Wales court. That is a case which reveals a long-term belief. When she was asked about this in cross-examination, her answer was she'd always believed that this is what was going to happen. And the original of the statement of claim, there's an amended later version. It's found at page 147 in the supplemental bundle. And again, it goes to the level of the wife's belief, but also what her attitude is to whether or not this would be material. Because, of course, there's a subjective element to this as to how this would impact on the wife. And this statement of claim is dated 16th of October of 2023. And what she seeks in those proceedings in Australia, which, as I say, are still continuing and have been amended, the amendment is at the end of the second supplemental bundle, the amended statement of claim, is that she seeks, and this is bottom page 148 in paragraph 6, a declaration that the third defendant, that's the husband, holds the monies received by him from the deceased, from the deed of settlement, dated 11th September 2020, being the sum of 14,777,180 received on 12th July 2022, and the sum of 20 million received on the 12th of August 2022, on constructive trust for the plaintiff as one of the lineal descendants of Robert Senior. And this is interesting in Australian procedure. This is sworn as an affidavit as well, so a little bit of a variation on our statements of truth. The verifying affidavit is at page 168. So the wife's belief is this is her money anyway. And the way that that comes about is she then also pleads against her other siblings that all the money that they've had should also be divided in sterpies into 4 shares, and that she should be gaining a quarter of that. So, travelling back in time to our Deputy District Judge, we have a wife who always believed this is her money and her siblings' money. What difference is the distribution of it in those circumstances going to make? And the answer must be either none at all, or this case cannot possibly proceed until the wife has resolved her own position.
You presumably
Her claim in Australia is worth £62 million.
you presumably don't accept that it's held on trust for her.
We do not. We don't accept that at all. But again, it's a case of, we say what's the impact in the impact on the wife of there being a statement of money is going to be paid to or gifted to the husband, albeit it might be postponed if the wife might be able to benefit from it. And the wife's attitude to that, it would be, I really don't care what you say. That's of no interest to me whatsoever. The money is mine. So how would that have any impact at all? The answer is, it couldn't possibly have any impact because that's not what the wife believes. And the wife has always believed this too, which raises its own nice questions as to, if the wife always believed she was getting a quarter of the estate, why didn't she disclose that herself before the Deputy District Judge? Well, my left friends might say, okay, well, we'll agree to set aside her property order. Difficulty they have with that is, of course, there'd be a Goddard and Watts direction just focused on that issue. But that again goes to the question of the wife's knowledge. We then have that the order itself is premised on the on there being a degree of support, substantial support, continuing in respect of the family itself. And if I may at this moment deal with a slight curiosity in the order, which was curious to the Deputy High Court Judge and was the subject perhaps of one of the reasons why the Deputy District Judge called the matter in, is it's found at page 15 of the supplemental bundle in the first volume at paragraph 11. Which is where it deals with the wife's income needs. And we say this was not a needs case at all, but for a reason I'm going to come to shortly. But it says here, and the drafting is curious, it says, it is recorded that it is an underlying assumption of this agreement that the wife will continue to work as a consultant at John Manners Mayer with an income of 12,000 Singapore dollars per month, together with the uplift in respect to the Central Providence Fund. That's the equivalent of a pension provision. Although the wife accepts that this is a matter over which the husband has influence, but is not within his ultimate control. It is recorded that it is the wife's expectation that her salary will be inflation-linked to ensure that she continues to receive an adequate level of income to meet her needs. Now, this is not without difficulty. First of all, its status as a recital in the order is it would not ordinarily be enforceable in say, the same way an undertaking on order would be. The remedy, if any, whoever the draftsman was must have had in mind was, well, if an underlying assumption goes, then potentially an order could be reviewed, perhaps on a barter basis. If that's the case, that application was never made and is never likely to be made. And it's never likely to be made for three reasons. The first one is the underlying assumption includes an assumption, which is expressed within it, that the job could be lost at any time. It's not in the husband's influence, it's subject to other people. The second reason why is the nature of the contract that the wife has, which is described as a sinecure, is only for 1 year. And that's what she tells the Deputy District Judge through her representatives. And then the third point is, on any view, the wife's needs were fully catered for. The wife had, in addition to the 5 million or so, which is set out in the judgment, she also had another £375,000, which had been paid shortly afterwards. And she had a housing need, which she met shortly afterwards, because at that time she was staying in friends' accommodation in Singapore. She had a housing need that was met by a purchase of a property in France for €2 million. So if one looks in the core bundle at page 122, one sees the analysis of the resources that are available to the wife.
I'm afraid it's rather difficult for us to understand these submissions when we don't have the Form Es. I have no idea what the parties' asserted needs, income needs were.
Well, the asserted income needs were dramatically higher and changing. I can tell your lordship what the figures were. The wife's first Form E in 2016, she'd said her personal need was 369,996, and she needed
Pounds?
Pounds, yes, and she needed another £223,000 for the children.
Right.
By 2023, in her Form E2, her global income need figure was 217,974. And by 2024, her income need had grown again to £637,677.
Sorry, 20.
24.
Did you say the second Form E was what year do you say that was?
So there's an E2 in 2023.
Right, but so from the point of view of prior to the date of, you said that her needs were fully catered for. If her Form E set out an income need of 370,000, her needs were not fully catered for.
Well, that's because she was accepting that wasn't, as we always said, was not a remotely realistic figure.
Well, that's a matter of debate.
Well, she did accept.
How can you sustain a submission that her needs were fully catered for?
Because I can come to. I'm coming to that in terms of what she said to the Deputy District Judge.
Okay.
Which then formed the basis of the order. So the figures which the Deputy District Judge has are conveniently set out by Deputy High Court Judge Hess at page 122.
Yes.
In the core bundle, and it's paragraphs 38 and 39, and we say that paragraph 39 is clearly the correct figure because the £1 million CHMRC was not payable. That was the whole point of living abroad. And there's never been any attempt to call in the £1.5 million due to the parents. And indeed, the parents have offered to say, if you stop litigating against us, we will certainly forgive it.
But it's still a loan.
It is still a loan.
Right.
But those two were on the alternate basis as to what was the likely future. And we know that the future was that neither of those two events seemed to happen. On that basis, the wife has a shade under £5 million, or 81%. And then if one looks over the page at paragraph 41, there's the additional $500,000 which the wife received, which converted to £375,000 at the time. So she has 5.375 million.
These are capital values, capital assets.
These are capital assets, yes.
So how does this address income?
So the wife, to meet her needs, she needs to have, or does deploy €2 million in respect of her housing need. And then the balance of it, we say, would be a conventional Duxbury calculation or capitalisation of the income need which she's described to the judge. And that figure, the figures for her Duxbury at that time would have been about one on her.
Sorry, where do we see this?
So the £72,000 is what we're going to say is what her income need is. I'm going to come to that with the Deputy District Judge's judgment.
Should we look at that?
Yes, I was simply answering my Lord's question. What we'd say is, if 72,000 was capitalised at that time, it would have been 1.396 million. So she has a great excess, which is why she wasn't arguing a needs case. She wasn't saying, I want some nominal maintenance order or anything of that sort kept in place. So turning to what was said to the Deputy District Judge, that's found in Supplemental Bundle 1.
I take it there were no documents prepared for this hearing?
For the hearing before the Deputy District Judge?
Yes.
There was a document prepared, which I'm afraid is not in the bundle, which he refers to, which was a joint email that was sent,
Right.
which again, perhaps I can locate and make it available to my lord and my lady.
Right. So what are we looking at? The hearing.
Yes. So the email that was sent in was intended to be equivalent to a D81. Would your lordship like us to try and find that? It was very much before the judge at first instance.
Right.
But it's not made there. But this is the transcript of
Yes.
the order. The first part, which is worthy of comment, is at page 25 in Supplementary Bundle 1, which is the parties have already long agreed this matter, and it's not later than the 12th of August of 2021. That's the ZIDIAS agreement. So they've achieved a ZIDIAS agreement 12th of August of 2021. They're then talking about the tax consequences, how they're going to draft the order, all those details. So it goes back to August 21. There's an argument about whether it goes back to an earlier meeting in April of 2021. The wife doesn't accept that, but we are all agreed, certainly by the 12th of August 2021, the ZIDIAS agreement is there. Now, at the bottom of that page of 25, Deputy District Judge says, I need to understand the departure from equality. Why is the husband not getting 50%? On the face of figures that are being put before him, it was suggesting possibly 81% is going over to the wife. And before he comes to that, he wants to deal with the date of marriage. And there's a slight error there, which is correct in statements. The representative for the wife says the ZIDIAS agreement is October 21. We're in fact agreed 12th of August 21. If you need a reference, that is page 250. But in any event, it's August 21. And they've been talking since April of 2021. And then the Deputy District Judge says at the bottom of 26, by way of background, okay, they separate July 17, March 2018's decree nisi. So it's taken quite a long time to get to this point. Now, I do not have any information about the income and earning capacities of the parties. So what can you tell me about the income and earning capacities of the husband, first of all? So Ms. Sisk, who is acting for the husband, is about to reply, and then he says, no, the wife should go first. And so the wife's representative says, up to page 27, there are lots of factual... so what I would say, sir, is this case where there is and remains an enormous amount of factual disputes. So I'm very conscious I want to temper my submissions so that they do not detract from the good progress the parties have made. It's not the same as the taking the view in Go Hill. It's simply where they're dealing with presentationally. And then the description is given line 19. So in terms of the income and earning capacity of the parties, so you may have gleaned from the papers, sir, that this is a family where there is enormous underlying wealth that is held in a group of companies in Singapore, which are owned by my client's parents, from whom she's currently estranged. She is estranged, not the two of them are estranged. Now, at the current time, Mr. Copinger-Symes sits on the board of directors of that company, which has an underlying wealth of around $700 million. Mrs. Copinger-Symes was a director of that company, but was voted off by her family. And so at the current time, Mr. and Mrs. Copinger-Symes both derive an income from the company, which I think amounts to around £6,000 per month. And that's £6,000 per month each. But Mr. Copinger-Symes is in the position of being a director of that company, whereas Mrs. Copinger-Symes is on a temporary consultancy agreement, which I think was for a year and had run out recently. I do not know whether she has had any discussions with her parents and her brother or Mr. Copinger-Symes about a renewal of that, but at the current time she's still receiving income, although she certainly does not have the certainty going forward, we would say, that Mr. Copinger-Symes enjoys about what his likely income is going to be. And the Deputy District Judge asks, so the intention is for him to continue with the company, is it? And it is. And then the Deputy raised the question, well, directors can be removed, so you know, I just want to understand that he's continuing and he's going to maintain that income. And then he's asked if he's a shareholder, and it's then, in this context, it said by the wife's representatives, well, that again is an issue that's in dispute between the parties. There are compromises which have been reached about disclosure, about the factual basis of the case. One of the reasons, sir, we would say there is a departure from equality is because Mrs. Copinger-Symes strongly believes that he will benefit in the future. Now, it's not said how much that benefit is going to be, but we do know what the wife's belief is, because she said time and again everything's going to be split into four. She said that there's going to be distributions, and we know the headline figure is somewhere in the region of 670 to 800 million US dollars. And that is what it looks like the husband's going to benefit from. And the wife, for her part at this stage, is not articulating anything about her needs case. And so it is reasonable to assume that she believes, at its highest, that the continuation of £6,000 per month will ensure that her income needs are met. And there's no dispute that both parties' housing needs are met. If the £6,000 was capitalised at that time,
is there nothing in this? I thought you were going to share something that the wife was saying, addressing needs. Needs. You're saying it's an assumption.
Well, she's saying that she, in the context of talking about income and earning capacity, she's saying she's relying on or saying that there will be £6,000 per month going forwards. Well, that seems to be saying, but she recognises that could come to an end at any stage.
I really don't understand, speaking for myself, how you get from my earnings, in inverted commas, is going to be £6,000 a month. That's my needs. I just don't. And the Form E said 240,000. Quite some distance.
369.
Sorry, 369. Sorry.
Yes, and
even more of a distance.
Yes.
I mean, it's kind of a leap.
Yes, it is a leap. And what it says is the wife is disavowing herself of that needs figure in her Form E.
Is she?
Yes, she is, because she's agreeing to a clean break, and she's agreeing to £6,000.
I see the word compromise, living with it, those sort of expressions littered through this hearing. It's, we've had enough, we're reaching something everybody can live with. I don't see anybody saying this is entirely consistent with our respective needs cases.
Well, they are saying that because they're asking the court to approve the order on the basis that it does meet their needs, and it is going to be a clean break.
Where does it say that?
That this is the fact that this is a clean break order
Yes.
is
Financial remedy claims don't always result in everybody's needs being met.
no, but if there's an expectation of there being wealth, as the wife had that expectation, then she
Disputed.
Well,
I've just done. So there's not. Okay, don't
Well,
worry.
I don't think there was a dispute that the husband was going to benefit from the family going forwards. That wasn't disputed.
Can I just ask you one other point in relation to an earlier submission of yours? The low down on page 28, Miss Sisk was for the husband or
Husband.
the husband.
Um,
So
but look, babe,
Miss Sisk said there, by way of illustration, the parties did receive some funds from the parents, significant sums in December. So that's December 2021. Is that right?
yes,
And they each received the same amount.
yes,
So a payment was made in December 21, after July 21, of $500,000 each.
yes, from the company.
Now, the wife might have benefited from that.
Well, the wife did.
Yes. Wife might have benefited from the payment to the husband of $500,000, but it was still made. How does that fit in with the case that if it had been known, if proper disclosure had been made, that would have resulted in no gifts being made? Here we have a gift being made prior to the conclusion of the financial remedy proceedings.
Well, the situation that was known to the wife was that there was that was in respect of the company, the 500,000 that was paid. That was the work. And that was to do with work that they'd done. So that's not in the nature of a gift.
So it was a contractual payment.
Yeah. Yes. So there was a company called Paternoster that was wound up that she was a shareholder.
Okay, so
And she
it
got her
wasn't a
share.
gift, it was a contractual payment.
Yes. Yes, indeed.
Thank you.
So it wasn't that. But my Lord, much more importantly, your Lordship asked me earlier to say about the needs point. Well, this was a finding below. If I might invite your Lordship to look in the core bundle at page 124.
Thank you. Have we finished with the deputy?
No, I'm just answering your Lordship's question.
Let's finish with this and then you can deal with that. I'd rather continue. What else do you want to show us from this hearing?
From the well, there's a description there of the page 29 of the background is still very poor. This is at line 15, and that Mrs. Copinger-Symes is keen. She says, I know Mrs. Copinger-Symes is very keen that I do point out to you that the relationship with her parents is particularly bad at the moment. They've just evicted her from property, and certain relations within the family remain very, very strained. And that was very much the nature. And then in terms of the loans, that's again understood that loans are made without expectation of repayment. That's referred to at line 24. The entire family have used loans in the past as a tax-efficient mechanism of passing money, and so these are loans that my client's parents have made to my client, to the parties. Historically, those loans have not been enforced. Although recently my client's parents have started to enforce any financial assistance they've given.
Yes.
And so on. And so there's a question whether or not there's a guarantee, which we say is not there. And then at page 30, we have the beginning at line 6, the description which is said on behalf of the wife. Well, so what the wife would say to that, i.e. that the wife is getting,
Yes.
he's taking 67% as figures, that is that the provenance of these assets are from a non-matrimonial inheritance which she received from her grandfather. Well, that's not entirely accepted. So part of the reason for departure from equality was says the parties are left with enough to house themselves. The origin of the assets comes largely from inherited wealth from my client's side of the balance sheet. And moving forwards on our side, it's believed that Mr. Copinger-Symes will have access to funds from my client's side of the family, which will not be open to her. That's not challenged. It said, we hope that the wife mends bridges with her family too, and we hope that they'll be forgiving of her, and so on.
That's again the husband.
So Ms. Vespizia is saying that she's expecting there to be money from the wife's family. And the husband's team are then saying, we hope the wife mends her bridges with her parents. And then there's a discussion about where the wife is living, and we know she then buys for €2 million in France. And then in respect of the undertakings and recitals, it's confirmed at page 35 that they've been fully explained to them in respect to this very fractured family, it says.
Where's that?
The Deputy Judge in line 15 says, I've read the various undertakings.
Oh, I see.
And so
Yes.
on.
Thank you.
And then the parties have been advised and that they know what's involved there. So it's against this background that the wife is left with over £5 million. She houses herself for €2 million. If her realistic needs figure was the £6,000 per month, which she describes as being her income going forwards, and which she's agreeing to a clean break on the basis of, then that would be deductibly about 1.396 million. She's
3.96.
1.396.
Oh, 1.396, sorry.
Yes, plus €2 million for housing means that she has still over £2 million left.
On my reading of the hearing before the Deputy District Judge, the whole hearing was seeking to persuade him that the husband was getting enough. That was his concern.
That was one of his concerns, yes.
Well, that seemed
holding.
to be, to me, his primary concern. It's
That was his primary.
it's always why is this imbalance? Or why is the husband getting so little? Don't see much focus on the wife's position.
And the answer
I
to
mean, is
that,
that a fair sort of overarching view of what was happening?
that was the primary concern, yes. And the primary answer at page 30 on behalf of the wife was at line 11, Mr. Copinger-Symes will have access to funds from my client's side of the family, which will not be open to her. And that's the critical line, 11 and 12 at page 30.
Yes, with your client's representative saying it was hoped there would be a bridge building.
Well, he hoped there would be bridge building.
Thank you. So
And-
we can put that away, can we?
We can, my lord. And then, my lord, looking at the question of the needs, we've got the Deputy High Court Judge, of course, had 8 days of hearing in respect to all this matter, so was
Yes.
able to consider all these matters again. He also had the Form Es. And at page 124, in a paragraph which my learned friends seek to interpret differently but is not appealed, the learned Deputy High Court Judge says at paragraph 45, so it's at page 124 of the call bundle,
Yes.
he makes a comment about whether or not the judge should have looked further at the matter. He quotes from Miss Justice Mumby, as he then was in L&L, and says the court is not a rubber stamp. He is entitled but not obliged to play the detective. He is a watchdog, but he is not a bloodhound or a ferret. Some judges may have interrogated the position in a more ferret-like manner and sought to identify what might flow from the word's underlying assumption. That's in respect of the wife continuing to be paid. But many judges would not, and I do not think D.J. Smith could properly be criticised for not having done so, and neither party has made any criticism of him in the course of the present hearing. The parties were both intelligent adults with proper legal representation, had been properly advised on the risks inherent in the order, were satisfied that their needs were met, and seemed to be content for the order to be made. Approving the order was an option for D.J. Smith, and this is what he did. They were satisfied that their needs would be met, and what far greater than these particular have. One believe that he would get income that could be up to 8 million a year, but that would then be paid over by gifts, and of course, gift is what then
How
happens.
does any of this square with the judge's fact findings at paragraph 50 on page 125 that when the wife did find payments, it's a horrible shock? Because everything you're saying is it shouldn't have come as a shock to her.
Well, that's the first clause, isn't it, my lady, of that paragraph? It should have done. Or perhaps
Well, it should not have done. Maybe it should have done. The fact he found out, and if it means that she wasn't expecting it.
well,
I'm just asking you, how does that square with your case that she knew? It's something that she did. She did it.
well, perhaps she should not have expressed that shock. The learned judge is right about that, because she did know this was all in prospect. And
It's findings of fact that it did come as a shock. He's saying that maybe,
Well,
if you stand back and look at it objectively, it shouldn't have come as a shock, but he finds as a fact that it did. And that seems to me to cut completely across your case on the facts, which is she knew all along and it wasn't a shock.
no, my lady, it's like if you know something's going to happen, say a dear friend is terminally ill and they die, it can still come as a shock. Doesn't mean you know it was going to happen. And that's the same as what happened here. And far more significant than that, and indeed one doesn't get a sense of it, but much greater part of the focus of the hearing was in respect of whether or not there had been a barge event. And in the context of that, what the learned judge found is at page 134, and that does deal with my lady's point about foreseeability and whether or not it was foreseen. And what the learned judge says is, had the husband genuinely not known anything about the likely arrival of gifts and
Sorry, which paragraph?
I'm so sorry, Lord, paragraph 68,
Thank you.
so page 134, then the case might look very different than that principle, but might have been problematic. View of the fact that both foreseen and foreseeable that the wife's parents might make substantial gifts to the husband in due course, whether inter vivus or on death. And of course, tragically, her father died shortly after the Deputy District Judge Smith order. So it was eminently foreseeable and foreseen. The only detail then becomes, well, how was it going to be achieved? And even then it takes place in the context of that extreme relation of they would be prepared to bone it if that meant that life would not benefit from it in any way, as was said. So we do rely on also the judge's finding that the needs were met. It's said by my learned friends that there's also a sharing case here, that the wife would have done this on a sharing basis. Well, there's absolutely no justification for that, and it's inherently unlikely that in a marriage of this length, where they had a joint matrimonial property, which the husband paid the deposit on, where he contributed $500,000, that property, joint matrimonial property in France, then became it would not have impacted on what she says is her belief system in any event. The they seem to be suggesting by that the learned judge had in mind some sort of opportunity to the wife to expand her case beyond that which he described. That hasn't been finally resolved as yet, but we say it's quite clear that what the learned judge was saying was that there were just really two areas in which the wife could potentially advance a further case, and that the word provisional is simply an expression of reservation prior to that rehearing. It's found at page 139, for example, at paragraph 89. And we disagree with my learned friends when they say it means more than what he was in effect doing was a God up what direction. He was saying, if we are to have a rehearing, it's to be focused, and these are areas where the wife could potentially improve her case. And he deals with two bases of need, having given short shrift rightly to any argument about reopening a sharing case. And at 89, what he says is there are two features of the order which left the wife in a position of uncertainty, which potentially left her in a position in which a needs claim may be justified to fill the gap. And then he deals with those two, and those are the only two. And they are the loan to the intervenor, which we say is resolved. The fact that the wife still has to pay the $850,000 the husband is already taken into account in netting her down to the 5.3 million figure. But that looks as if it's going to be...
Why does the wife have to pay the 850,000? Why should the wife have to pay the 850,000?
Because that was a court order.
Yes, I know. But if you were starting again and the husband's got $20 million,
yes, because
$40 million, why does he need 850,000?
Well, he has a minimum of a sharing case in any event, born of the fact that he contributed money to the marriage, he contributed earnings.
Was he putting forward a sharing case?
Well, he was not putting forward a sharing case.
He wasn't putting forward a sharing case?
No, because he didn't need to.
So he would try and... So the 850,000 was because he needed the money. It's for the children's school fees, is it?
No, the children's school fees were provided for separately from
so the
income on the
850,000
next.
is just for him
So the 850,000
to meet his needs.
to meet his needs.
Yes.
Yes.
Now, if he doesn't need the money because he's got 34 million US dollars, why should he keep the 850,000?
Well, the wife's case on that is it meets his needs. We would say it would be on a sharing basis in any event.
So you'd have to start again and argue again, this time on the basis of a sharing.
No, you wouldn't, because the...
This is what I'm having. You'll understand this, Todd. I'm not as familiar with this area of law as you are. But my understanding is, if you say, I'm going to divide up the assets, not on the basis of sharing, but on the basis of needs, and it turns out you don't need the money because you have much more money than your wife does anyway, it's difficult to see how you can say that doesn't make any difference. And the way you say it doesn't make any difference is, oh, he's got another claim to it. He does actually have a sharing claim. But that's obviously a different way of keeping the 850,000, which would have to be argued.
Well, the court does not proceed. The court inquires as to his needs, because the court required to. that doesn't mean he hasn't worked on the basis of this is already something that he's entitled to, both on a needs basis and on a sharing basis. So yes, all the deputy district judges' questions are focused on needs, as they ought to be, because it's the needs that are all important. But that doesn't mean he wouldn't have had a sharing case. And when the deputy high court judge comes to deal with, well, where would there be points of departure in respect?
Yes, he doesn't deal with the urgent case. That's, I understand that. These are his provisions, just these two areas. But I'm struggling with the idea that the 850,000, the deputy district judge thought that was appropriate for the husband to have because of his needs. And now, if he's got access to tens of dollars, that doesn't seem to be the case. It doesn't seem to need it. You say, oh, but he would be able to keep it on another basis. But that case has never. It would have to be made out.
Well, it's the nature of the whole remedy order is can take into account a number of different strands.
No,
All the other people didn't have value. And then the other part, in respect of the income, that was always known to be fragile, and then guaranteed its end by being the company. And it was the husband alone who voted against the wife being dismissed from the employment of the company. So he did try and stop her being dismissed, but was outvoted. And that was always known. And her remedy in respect to that was to say, well, an underlying fundamental assumption has potentially been interfered with. Well, that was never pursued and never likely to be successful, not least because it was a situation of her own making, and it was something that she already knew could be taken into account. And it can be, and the Deputy High Court judge must have taken this into account, it must have been the case that in approving this order, he was also very alive to the fragility of that money, and indeed expressly said so, well, this is not in the husband's gift. And that's then repeated in the order. So it was always known that could be lost. And those two matters...
Do we have his judgment?
Oh, we do, my lord. It's very short. It is in the court bundle. Sorry, it's in the supplemental bundle. Sorry,
it's page 39 of the supplementary.
Indeed, page 39. Thank you. There he adopts at page 39. He adopts within that in paragraph 2 that this is a significant departure from equality. That the parties have filed the party, but he'd raised this is paragraph 2. both parties solicited information, which of course includes expectation about future wealth, which well as a provider that this order should be approved, notwithstanding that there is quite a significant departure from equality in relation to capital assets. That's the language of sharing. I have, however, been told that both parties are comfortable having taken legal advice in relation to division, and that in part this reflects in part reflects derivation of the assets, in the wife's parents and grandparents have historically had business interests, which means there is substantial wealth which stands behind them, and both parties benefit from loans and gifts which were made by the wife's parents over time. And so that's just in
the last part of my points made by the husband on the appeal. I'm going to just take a moment to deal with the, let's call it what it is, the fraudulent conspiracy that the judge finds in respect of the if I may.
Well, quickly.
I'll do it I'll just do it quickly by reference to some of the big dates as well. The original application for financial remedies is made back in September 2017, and the parties make their Form Z in December 17 and January 2018. And while I'm on the topic of the Form Z, I'll just give you the figures. The wife's income needs in the Form E were put at a global figure of 593,928, which is the figure that Mr. Todd divided into 369,000 for the wife and 223,000 for the children. She put her capital needs at £5 million for a property in London. And the simple point, Moylan Friend has already taken you to the part of the judgment that sets out the assets at that point. The email that was sent to the Deputy District Judge appears in the supplemental bundle at page, or an analysis of it appears at page 664 of the supplemental bundle. And this was a document, an agreed document put before the judge, simply recreating the presentation that had been put.
The figures in the email. Right.
So you get something more akin to a Form E type presentation. So the assets are worth between 3.5 million and approximately 6 million. And we know that the additional payments of $500,000 have been paid to both parties, and that's set out in a separate part of the judgment. And that's the landscape against which the Section 25 criteria is assessed. And as we know, on the 12th of July 2022, the husband is paid $14 million US. At that point, on the exchange rate at that point, and we've got the figure wrong in our skeleton, using the exchange rate of 0.8431, the figure is £12.458 million. So what is being added to this asset base is a figure which is 2 to 3 times the asserted base. And we know from the judgment that the husband knew the size of the payment by at least July 2021, and he was aware that a substantial gift was going to be made by late 20 or 21. So he knew this at the round table meeting in April 2021. He knew this when the Zidias agreement was reached. And of course, he knew this when the order was approved. So when one looks at the transcript, it's almost the mental gymnastics one has to do at every point of that transcript, when you have to remember that the truth is that the husband knew that he was about to receive $20 million US, or 14 million US dollars, 12 million pounds. The mental gymnastics are extraordinary. We know that he's paid a further 20 million US in August 2022. He then launches enforcement proceedings in December 2022, and he resists within those proceedings providing disclosure, but he's ordered to do so. As a consequence of that order, in April 2023, he discloses that he had $28 million dollars in bank accounts and a property worth 6.5 million euros. As a result of that, my client applied to set aside the March 2022 order. The trial was heard in May 2024. From May 23 until 31st January 24, the husband's case was that the $14 million was first offered in July 2022. He did not disclose the decision to postpone the payment in July 2021 and the decision to postpone the payment in March 2022. That false presentation was made in concert with the intervenor and my client's 3 siblings, Teresa, Edward and Isabel, who all made statements confirming this false story, despite knowing that the 2 postponements had been made. And it's not until January the 31st, 2024, that materials finally disclosed, which demonstrates that they had all lied. Judge Hess makes a finding of fraud. That's what it is. And that fraud is perpetrated by the husband in cahoots with the intervenor and the family. And the conspiracy element is dealt with in the judgment in the core bundle, page 130. Sorry, I'm not in the core bundle. Give me a second. 130, paragraph 63(2). It's a troubling feature of the statements of the husband, the intervenor, Teresa, Edward and Isabel, produced on the same day, 24th of July, that all of them seek expressly and specifically to for the